Just skip quickly to privacy. And I think that's a slippery area too, because there's so much with Article 8 and Article 10 and the PCC code, and yet much of Leveson early on was celebrities complaining about their privacy being invaded. Have we learned anything, and can we, journalism, learn from the judge's views in the Karina Trimmingham case the day before yesterday?
Well, I think what we understand about privacy is that it's tremendously fact-specific. So somebody has to make this adjudication between 8 free speech, privacy, and 10 free speech. And that will always be fact-specific. There will always be, you can't make broad brush decisions. You have to say, well, the facts in this case are as follows. And there was a period with the press where they said, I think, crudely paraphrased, we don't want the PCC to do that because we don't actually, we're on the free speech side of the argument, and we don't believe really that there's a sort of, the PCC just vacated the playing field. And so claimants and lawyers said, well, there's no bother, don't bother with the PCC, we'll go to the courts. You then got a series of judgments in the courts, which I think when you read the facts of the case as opposed to how they were reported, and the judgments in them showed judges very carefully weighing these issues. And Karina Trimmingham is very different from Ryan Giggs, so you get a different result. I think going forward, the question for the press is, and it comes back to the question about Leveson and this arbitral system. If we so dislike Mr. Justice Eadie and the judges taking these decisions, then why don't we do it ourselves? Why don't we have a forum, a meaningful forum in the PCC, which would do it so that people don't have to go to the courts? And I don't think the PCC, I don't think the press has yet sort of grasped this issue or shows any sign of wanting to discuss it. But the fact, I think, remains that if we don't do it ourselves, people will carry on using the courts, which is a very expensive and for the press risky route, because you do start getting a body of case law built up on the worst possible cases for the press.
Mm-hmm. What about what's in the public interest and what isn't in the public interest, and how do we define it?
Well, there is a definition in the PCC code, which all newspapers are signed up to. And the interesting thing about the spate of cases, there was a spate of cases about this time last year, which are all around these so-called super injunctions and injunctions, in which actually it was mainly the Sun was testing this in court and defending all these cases. And when they got into court, it is decreed that the first question the judge has to ask, and this is under Section 12 of the Human Rights Act, the judge has to say, are you arguing this is in the public interest under your own code? And repeatedly in these cases, the Sun either wasn't in court or said, no, we're not arguing that, which automatically meant that Eadie was bound to give more balance to the Article 8 questions. So I think, for me, the lesson was we either believe in the code. I think the code is perfectly good code. It could probably be improved. It's a perfectly workable code. But as an industry, you're either going to believe in it and fight law cases based on your compliance with it, or you're not. And the more you've got papers like The Sun going to court and ignoring the code, the more people think, well, the code is worthless. So, if we're going to have self-regulation, let's have it and let's abide by it, but let's show to the public that we believe in it.
Yeah, I think the code's very interesting, because I think and I think it's good too, but I think there's some areas that can be interpreted in different ways. I don't know if you read in the British Journal Review, James O'Brien, the broadcaster, wrote a piece 2 or 3 issues ago, where he was basically arguing that what's in this it has become a terrible cliche. It's all right saying it's in the public interest, that it interests the public, but does that mean it's in the public interest? But sometimes those things do coincide. I asked a question earlier at a panel that set up here and said, if you get a situation, we come up with some town in the north, it doesn't matter, a footballer in a club, takes a girl out, has sex with her, he's married, he's got kids, it gets out, the girl complains, not to the police or anything, but complains that he led her on and that he told her he loved her, whatever story you want to. The public, does the newspaper refuse to publish that? Well, yeah, the newspaper probably does because it contravenes the code. But the girl, let's just say when we have a new regulatory body, goes to the regulatory body and says, well, why can't I talk? Why are you suppressing what I want to say? Because this man treated me very badly. How would you deal with it, or how can one deal with a situation like that? That's a curve.
Yeah, that's a classic one where you've got two countervailing things. And if you read a lot of these judgments involving, it wasn't only ED, but mainly ED this time last year, quite often there was something, blackmail is a strong word, but quite often there was a sort of attempt to gain money in the first instance. Sometimes there were particular family circumstances where there was tremendous mental stress involved on the families and their children. Sometimes the parties had put it behind them and were trying to rebuild their lives. I think all that has to be put in the balance. But you're perfectly right to say, Article 10 says that the woman in the case has a right, but the law says that should be balanced against other rights.
And the code will actually come down on the side of the footballer, basically, which seems to be discriminating on behalf of the famous, and therefore normally the wealthy. And it's because the argument being that the story doesn't exist if he's not famous, and it's just two ordinary people in a pub, and the paper's not interested anyway, which seems to be a loophole that does inhibit the free speech of everybody, which it should be encouraging. Is that all right?
Well, to the extent that the people who are newsworthy because they're famous, I suppose the law is being written with a bias towards those facts. Yes.
Okay. What about checkbook journalism? I'm always interested. It's people sneered. Journalists only exist on checkbook journalism, but bearing in mind paying for information it appears permissible almost everywhere else. In police security services, everybody pays for information. It's the way the world has gone round, rightly or wrongly. Should it be considered wrong when it's practiced obviously not in buying kiss and tells, I'm not talking about that, but in not paying policemen, it's illegal, but, or public officials, but paying people for information. And we know very well that when the papers have a thing saying at news desk hotline is, they will pay somebody a tip fee.
Well, we don't pay for information, but that's probably because we can't afford to. But you can't say that there's anything wrong in general with paying for information. There's clearly a problem in paying corruptly for information. So if you pay public officials, that is corrupt, and I don't think that should be done. There's obviously the other problem is that if it does the payment in some way pollute the information. So by the act of payment, are you enticing someone to say something that they wouldn't say otherwise, or to change their story in some way? So I think payment has got some problems with it, but is it in general wrong, except in the case of public officials? No.
And obviously not from some of the things that your own paper's been involved in, and that if it is in the public interest, and there is no question that it is in the public interest, then one would pay for the information, because otherwise what is in the public interest may well not get out.
Yeah, but because there is a spotlight on everything we're doing at the moment. So, yesterday our reporter Amelia Hill of the CPS said he wasn't going to proceed with a prosecution against her, and one of the factors there was because the Guardian hadn't paid the policeman. And I think that was a good decision of the CPS, and I'm pleased he reached that decision. And the other factors were that it was clearly in the public interest, the information that she was writing about. So I think the papers just have to be a bit careful, obviously, at the moment. If, I haven't heard anybody actually advance the public interest in paying policemen or prison officers or NHS people to disclose medical records, because I think that's, I would be dismayed if journalists did start advancing that.
I agree.
At the moment.
But whistleblowers are more often than not public servants.
Well, I think a true whistleblower, the language of whistleblower is they are blowing the whistle because they believe they're exposing iniquity, and that should be their motive, and that's the cleanest motive. And if you get into court, that's the best way of defending it. At the moment you've paid them, the counsel on the other side and the judge is going to say, well, wasn't there that true motive? So I think it complicates it, which is why we don't pay. I'd rather a whistleblower acted out of integrity and because they were so distressed at what they were seeing, because that's a very clean thing to argue in court.
Yeah, I understand that, but it's not real life, I think. In that the whistleblower may well be doing it for your motives, but thinks.
Well, I would back our investigative record against any paper in Britain over the last 5 years. We've written about torture, about tax avoidance, we've written about rendition, we've written about arms dealing, about police misconduct, about News International. We've done it without paying a penny.
Yeah.
So that's real life. You can do this journalism without paying.
So you wouldn't have paid for the expenses, MP's expenses story?
Well, exciting. That's a classic. I think the Telegraph was perfectly defensible in paying for that. I probably wouldn't have done, but I'm not saying that would be the right. And I think James Harding had the same thing when he was on the Times. I think the circumstances in which that came about, I can understand why James didn't and I wouldn't have done, but I also think it was perfectly justifiable for Will Lewis to pay for it.
In your Orwell lecture, I think you said that the next day, you were talking about the next day's newspapers barely covered the event, which was actually the Media, Culture and Sports Select Committee. And thus setting in tone, you said, for the next 18 months, setting the tone the next 18 months. In other words, that the other papers ignored what was going on. But isn't the Select Committee, don't you think, becoming a group of not very knowledgeable politicians posturing? And I'm not talking about the Leveson inquiry, but that Select Committee that is now becoming, that is spilling over in a way and is becoming a television focal point, and indeed some of the people on it become very well known. Has it been? So
that was July 2009, and the story we had run was the story that said effectively that one of the largest companies in Britain, the most powerful company in the world, arguably, the media company in the world, had at board level sanctioned the payment of hush money in order to conceal a criminal offence within the company. Now, if that had been about a bank or an engineering company or any other company in Britain, that would have been covered by everybody. That's the highest, the most serious accusation you could really make against a company. News International came out and said it was untrue. The police said, we're not interested. And then Nick and I went in front of the Select Committee the following Tuesday, and Nick's source was so outraged by the lies that News International were saying, that we had deliberately made it up, that he produced these documents before the Select Committee. And Andrew Sparrow, veteran Guardian blogger, said it was the most dramatic moment he'd ever seen in a Select Committee. He'd been covering some Select Committees all his life. And the room was packed with journalists. And hardly anybody wrote about it the next day. It was just a remarkable thing, that this thing that had happened in public, this dramatic piece of evidence against a really major corporation, and nobody wrote about it. And that's why I said that sort of set the tone for the next 18 months, where everything that happened, so Nick, was very bloody-minded. He thought, okay, if they're going to call me a liar, I'm going to set about and prove this.